That is why I would just conclude by this submission by saying that when existing laws,
आपने जो पूरी अपनी बहस शुरू की है वो आपने किसी और बेसिस पे शुरू किया. आप अपने आर्गुमेंट्स करते हैं तो ये सारे मसले आपके खड़े नहीं होते. But sometimes it is not very easy to give a yes/no answer. It was like the young, on a lighter note, माहौल भी जरा ठंडा रखते हैं. On a lighter note, a lawyer was battering a lady during cross-examination. The husband representing the lady, and he said, "Have you stopped beating your wife? Answer yes or no." So keep things light and move ahead.
So I'll just conclude my this submission by saying that the 1980 rules or the 1956 rules, though they were existing laws when the Constitution came in, but saying that they were the law within the meaning of Article 191 would be a contradiction.
Okay, can I ask a question?
आगे चलता हूँ.
ये एक सवाल सुन लें कि आप ये कह रहे हैं कि वैसे तो the rules are law, but for the purposes of 191 they are not law. Now wherever the word law has been used, what principle of interpretation will be applied to see whether these rules or any other rules will be applicable there in the term law or not? The reason I ask this question is that the first day, my question to you was that if subject to the Constitution and the law meant law just an act of Parliament to the exclusion of everything else, then maybe the word law was not the right word. So when we look at the word law, we have to read something more than just an act of Parliament. So the act of Parliament is there, but other things are there. Now you are saying उसमें से आप ये rules निकाल लें because यहाँ rules नहीं apply होंगे. Then in some other provision rules डाल दें because वहाँ rules apply होंगे. So there doesn't appear to be any principle of law that one is following on the basis of which one would determine where to use what part of law.
इसमें learned Attorney General, since this discussion is in the context of Article 191, can we construe Article 191 that the rules may be made by the Supreme Court subject to the rules that it will make? This is the simple question. You see, it automatically excludes the rules that will be made.
My Lord Justice,
because it is in the context of Article 191.
एक बात AG साहब और भी है, what I understand from the questions of the learned colleagues, that is subject to the Constitution and law. Obviously the Supreme Court may make the rules. Once the rules have been framed, and maybe this may be included in the definition of law, but whether there is any sunset clause after making rules by the Supreme Court, the word law has become redundant. Is the purpose then? Yes. If we are talking on it, then once the Supreme Court has made the rules, that has become the end of the story, and they cannot make further rules.
Redundancy.
And the redundancy attribute हो रही है ना, अगर हम उसको करते हैं कि Supreme Court rule बना सकता है. Supreme Court has made up the rules. Then what is the purpose of the law used in the Article 191? Because there is no sunset clause. After making rules, obviously it will be a sunset clause for that. जैसे आपने नीचे पढ़ा है ना कि वो हाई कोर्ट के लिए उसकी प्रेसिडेंट साहब नहीं करते तो वहाँ sunset clause है, unless such time the president make the rules.
So as I see it, the word law is evergreen in 191, and secondly, it might entail other instruments, but what I'm concerned with right now is the Act of the Parliament is also there, and that is enough for me to go forward.
Yes. So
are you going to answer my question? क्योंकि वो तो रह गया.
According to you,
I owe an answer to a lady.
According to you, once the rules have been framed, in exercise of constitutional jurisdiction that 191 confers, they are law. Number one. Number two, because of the language of 191, it is an exclusive power given to the Supreme Court rules.
Where does the
Subject to the Supreme Court may make framed rules.
Yes.
So the Supreme Court framed rules.
And subject to the law and the Constitution.
what you're saying is, once this law has been made or framed by the Supreme Court, can a subsequent act of the Parliament trump it, or modify it, or render it redundant?
My lord, there is no fetter, there is no restriction under 191 on Parliament's power to make any amendments, barring one, which is that it should not in any way undermine independence of
वो
judiciary.
तो standard test
वो
लगेगा ना, all
extended
the
test है,
first-
उसके अलावा there is nothing in the language of 191.
अगर मैं आपकी बात समझ
So,
पाया हूँ
if you invert the
Ladyship, my lord is not letting
Equation.
me answer your question. So.
if you invert the equation, the same thing can be done by the Parliament, the same thing can be done by the Supreme Court. Both can make the law as far as practice and procedure is concerned. So you say there is no fetter on the power of the Parliament to amend the rules that the Supreme Court makes.
Yes.
So if you invert the equation, then there is no fetter on the power of the Supreme Court to amend the law that the Parliament makes.
But then it's
Subject
Subject to what?
Law.
Subject to law.
the rules of
Law
Supreme
वही है
Court,
ना,
the
आप कह रहे हैं
Supreme
ये भी
Court
law
will
है,
be
वो भी law है.
No, no, no.
So then there is
नहीं,
an
नहीं,
interaction
नहीं.
of two laws.
The interaction.
Or a conflict of two laws.
There is no, there can't be interaction to two laws. In that broader sense, Constitution also is a positive law. We can't possibly say
so
that.
then the Parliament that makes law that you're saying subsequent.
Parliament is the lawgiver, my lord. Let's acknowledge it.
Hold on. It stands on a higher pedestal.
Parliament is the lawgiver.
ये बताइए
जो सेपरेशन के ऊपर जब बात करनी है, मैं वहां तक अगर पहुंचा तो यही बात करूंगा कि
Learned Attorney General, ये बताइए
अगर ये आपका आर्गुमेंट मान लिया जाए तो ये बता दें कि 191 का मकसद क्या था?
Learned Attorney General, ये बताइए, if under the obligation under the convention, the Parliament makes a law that all jail appeals shall be fixed within 1 week from the day they are presented, will they not prevail over any of the rules made by the Supreme Court?
Yes.
And those rules will then be subject to this law.
yes, that's right, my lord.
Mr.
And
Attorney
independence
General,
of judiciary is not
And
affected.
independence of
Mr.
judiciary is
Attorney
not
General,
getting affected by this. Access of
Mr.
justice is
Attorney
being
General,
advised.
if the argument is accepted in toto, then what was the fun to insert this 191, Article 119 in the Constitution?
I didn't get the question, my lord.
My question is that what was the fun to insert 191 in the Constitution if it was not the intent of the legislator that the authority has been given to the Supreme Court to frame rules?
Yes, the authority has been given, but with a preface, with something which it is subject to, which is the Constitution
It
and the law.
doesn't mean anything. If it was
That's
exclusive
why
within the
the
domain of the
argument-
legislator, then this 191, that is of no use.
How so? I didn't. I still
What is
haven't
the
gotten
purpose of
question.
what is the purpose of making these rules?
But,
To give effect to the constitution and law.
and to have the court function, and of course, that's the purpose.
Because the constitution and law is not so exhaustive. That's why rules are framed to give effect to the act and the constitution.
May I answer the question first?
Your Ladyship, the term law as used in the Constitution, and as it has, you have noticed, it has been used at various instances. In addition to as an act of parliament, that term specifically act of parliament has been used. We will look at the provision, and from the provision we'll call out